Well, good afternoon to all of you. Sabi nila, naka-fatigue uniform daw kami ni JG. I prefer to think of us as the Filipino version of Maroon 5. Although wala na si Terry Ridon dito. And I'm the lead singer. So, banda ka na lang, JJ. Nagigitara ka naman. At the drums. Anyway, now, JJ and I decided that we would segregate the discussion. I will focus more on the constitutional issues, while JJ will really consider and discuss more of the geeky issues relating to the law. Part of it is because I'm the lead singer and he's in the band. No? But anyway, let me start by saying that our petition is really substantially different from all the 9 petitions filed. And the reason is we're trying to enforce a UN Human Rights Committee view in the case of Alexander Adonis versus Government of the Republic of the Philippines, where the UN Human Rights Committee declared Philippine criminal libel law to be inconsistent with Article 19 of the ICCPR, or freedom of expression. How did the case come about? No? Well, he was a broadcaster in Davao. He reported on the basis of a prior newspaper report published by Abante that then Speaker Nograles was seen running around in his full naked glory after apparently he was caught in bed with a married woman by the husband of the married woman. Now this incident has since been referred to by citizens of Davao as the burlesking incident. Now because of that broadcast, Alex Adonis was sued for libel. And meanwhile, after he was sued, he was transferred to Cagayan de Oro by his station. And of course, while he was in Cagayan de Oro, trusting that his station was defending him in the case, it turns out that he has lost legal representation. In other words, he was declared to have jumped his bail. And because of that, the court proceeded to receive evidence ex parte. Of course, that evidence consisting solely of the testimony of the former speaker. As a result, he was convicted. And he found out about his conviction on the day itself that he was arrested to serve his prison sentence. He was sentenced for up to 4 years of imprisonment. He served 2 years out of the 4-year sentence. After 1 year of imprisonment, when Paraan of NUJP told us about his fate, so we decided, since I had the UP Law Center lecture in Davao City, to go to the penal colony in Davao. It was very far away, to talk to Alexander Adonis, to explore about this possible legal remedy, which is a complaint in the Human Rights Committee. I explained to him that at most, the UN Human Rights Committee could declare criminal libel in the Philippines to be contrary to freedom of expression, but it will not in any way alter his conviction. It will at least save future journalists from experiencing the same fate that he did, in the sense that perhaps the committee can compel the Philippine government to do away with criminal libel. Now, many years after the petition was filed, in fact, it took us 4 years, the UN Human Rights Committee came up with this view, saying that criminal libel in the Philippines is contrary to freedom of expression. That view came out in October of last year, but was received by us only in January of this year. Substantially, the committee said it was contrary to freedom of expression because, number one, imprisonment is disproportional to the means that the law seeks to achieve, and that is the preservation of the right of privacy for individuals who want to be left alone. Secondly, there is an alternative, civil libel. Number third, the committee said that contrary to its opinion number 34, criminal libel in the Philippines is additionally defective because it does not recognize truth as a complete defense. Now, in the resolution of the view, the UN committee asked the Philippines to avoid similar repetitions in the future and asked, in fact, the country to review its existing criminal libel law. There were 2 dissenting opinions because the 2 dissenting opinions wanted it to be very clear that the Philippines should decriminalize libel. But the language used is that they must take steps to review their laws to avoid similar events from being repeated, including examination of its existing criminal laws. Now, what is the relevance of that view to this view? Well, as a state party to the ICCPR, we have also ratified the optional protocol to the ICCPR, which gave the UN Human Rights Committee jurisdiction to hear individual complaints filed by Alexander, Adonis, etc. The problem, though, is even if the decisions of the Human Rights Committee, according to the optional protocol, are non-binding, still, they evidence breach of our treaty obligations under the ICCPR. And under our domestic law in turn, the latest pronouncement of which was in Magallona versus Executive Secretary, the court reiterated, again, for the 100th time, that because of the incorporation clause, generally accepted principles of international law automatically form part of the laws of our land. And in cases such as Angara versus Tanyada, the court said that one of these generally accepted principles is that of pacta sunt servanda, meaning the treaty obligations must be complied with in good faith. Now, this means therefore that although the Human Rights Committee view is per se non-binding, as evidence of a breach of a treaty obligation, we need to comply with the view. Because according to the committee, our criminal libel law is in fact contrary to freedom of expression under the ICCPR. Now, the Philippines actually has 180 degrees from January, 180 days from January to comply with the view. After which, there will be another occasion for the Philippines to comply with the view, and then it will be sent to the Special Rapporteur on compliance with views. No? Meaning, the committee will not stop hounding the Philippines until we have actually decriminalized Philippine libel law. Strangely, well not strangely, but coincidentally, next month, the Philippines is the subject of regular periodic review by the ICCPR Committee, the Human Rights Committee. And I'm sure one of the things that could be brought up against the Philippines is what has it done to comply with the view that it must decriminalize libel. Well, we will be embarrassed when we are subjected to this review. Why? Because instead of decriminalizing libel, through the Cyber Prevention Act of 2012, we have even expanded the coverage of libel now to include electronic libel. Now, in the past, as a defense counsel for libel cases, it has been standard defense for us to include that since there has yet been no law criminalizing electronic libel, any libel charge on the basis of an online article should be dismissed, no? On the basis of legality or nullum crimen, nulla poena sine lege. The last decision of a fiscal that upheld this kind of a defense was in fact against a libel complaint filed by no less than Congressman Manny Pacquiao in General Santos. No? There, the provincial fiscal said, well, he's complaining about an online story, there is still no online libel, at least at that time, and therefore I'm compelled to dismiss the case. No? So here we are now, instead of decriminalizing, we have expanded the coverage. Not only that, we have tripled the penalty. The penalty now is prison correctional from prison mayor. From 2 years to 6 years and 1 day, it is now 6 years and 1 day to 12 years. Now, because we have tripled the penalty, we have also done away with the possibility of parole for individuals who are convicted of libel. Why? Because as you know, the indeterminate sentence law only grants the right to parole if the maximum penalty imposed is 6 years and 1 day. There is now, therefore, a sure prison term for individuals convicted by final judgment for libel under the Cyber Prevention Act. Not only that, strangely enough, the law, because you could file a libel suit against a published article and an online article, says that the prosecution under the Cyber Prevention Act is without prejudice to another prosecution under the revised penal code. So columnists and bloggers like me, since my column is also published in an electronic version of the newspaper and in my own blog, can be sued twice under the RPC and under the Cyber Prevention Law. No? And moreover, because the sentence was tripled, the question is asked, what is the basis for this harsher penalty imposed for electronic libel? Certainly, it can't be for another reason other than the above reason why we have libel in the first place, to protect the privacy of individuals who want to be left alone. And yet, why is it that when a private individual sues on the basis of a printed article, the penalty is even subject to parole and maximum of 6 years, and yet when he is convicted under the Cyber Prevention Act, the penalty is not subject to parole and is up to 12 years. Meaning it violates the principle of equal protection of the law, which says that people who are belonging to the same class should be treated in an identical manner. Remember the 4 elements of equal protection of the law. Let me see if I have students here from my Constilo too. Oh, I do! There, stand-up recitation. Come on. The price, if you get the answer correctly on the 4 elements of equal protection, is what? A free trip to Muntinlupa to observe the first convicts of the Cyber Prevention Law. Well, you must be similarly situated, not limited to existing conditions, applicable to members of the same class. Okay, so there must be, in fact, a valid basis, a state interest, in fact, for the distinction, for the law to be upheld. And I don't see any valid reason for the distinction. Now, of course, I could go on and on, but the problem is my fellow band member, JJ Dicini, may run out of things to say. So I will stop now because I promised that I will leave him ample materials to discuss with you this afternoon.